All right, everybody, if you'll take your seats, we'll begin with the last panel, titled Do Administrative Agencies Systematically Under Protect the First Amendment? This is based on a paper that Professor Bernstein authored. We're a pleasure to have all the panelists, but I do want to reiterate my thanks to Professor Adler for co-organizing this. I wanted to plug your book, Jonathan, Business in the Roberts Court. The problem is the library copy doesn't have the dust jacket, so waiving this doesn't really help. But I highly recommend his book, Business on the Roberts Court. And with that, I'll turn it over to Jonathan.
Great. Well, thank you. Thank you for sticking it out on a Friday afternoon. What we in Ohio would consider a lovely Friday afternoon, nice and balmy, for our final panel to look at the question, do administrative agencies systematically underprotect the First Amendment? Those of you who are here this morning have heard me speak enough already, so I won't subject you to much. I'm going to super briefly introduce our panelists, but as always, their full bios are in the booklet. We're going to start off with Professor David Bernstein, who is a professor here, who authored a paper suggesting that administrative agencies do systematically underprotect the First Amendment. We will then hear from Professor Shep Melnick, who is our token political scientist, who came down from Boston College. Then we will hear from Tamara Piety, who's a professor of law at the University of Tulsa, and then rounded out with Professor Sam Bagenstos from the University of Michigan. That's enough of me. David, the first 10 minutes are yours.
Sure. Thank you, Jonathan. So, over the last few years, there's been something of an explosion in literature in the legal academic world about especially among legal historians, about administrative constitutionalism. And this particular version of administrative constitutionalism means that administrative agencies develop their own internal cultures of what values they think should be protected by the Constitution, values of overarching importance that may trump other concerns, and these values, importantly, may have no basis in or even be in conflict with Supreme Court precedent. The overall tone of this literature is very positive. For example, celebrating the NLRB and the FCC for developing administrative anti-discrimination rules. These agencies decide internally that the Constitution protects a right of non-discrimination in employment, in closed union shops, and in government licensed communications entities, respectively. And they enforce these rights despite a lack of judicial guidance or statutory language to rely on. My role here today is to tell a more cautionary tale about administrative agencies expanding the scope of anti-discrimination law based on their own understanding of constitutional values. Much of the administrative constitutionalism literature that I just referenced discusses agencies charged primarily with other tasks, like regulating the airwaves, incorporating equal protection when they're engaging in government action, giving somebody a license. That's, seems reasonably persuasive and sound, and that's why the literature, I guess, is so favorable. But my paper, instead, is about anti-discrimination agencies themselves, like the Office of Civil Rights, like the Department of Housing and Urban Development's Anti-Discrimination Office, and so forth, expanding the scope of anti-discrimination legislation in ways that threaten constitutionally protected civil liberties in general, and in coordination with the topic of this panel of freedom of speech in particular. So I begin by discussing several examples of anti-discrimination agencies abusing their power at the expense of constitutional rights. One of these we heard about in detail already at lunchtime, which is the Federal Department of Education's Office of Civil Rights during the Obama administration, passing a nationwide speech code via a settlement with the University of Montana, and also trying to impose denials of due process on students accused of sexual misconduct through a guidance letter. We all heard about that already, so there's no need to belabor that. Stewart portrayed that as the result of ideologically driven top-down management by Obama appointees, which is entirely plausible. I want to point out that my examples don't only relate to examples like that. Another example is the Department of Housing and Urban Development telling neighborhood community groups that they were acting illegally and could be fined or even put in jail for doing things like organizing community meetings, filing petitions with the government asking not to have a halfway house for former drug addicts in their neighborhood. This involved one of my sort of favorite examples of someone not respecting civil liberties. After HUD itself decided not to do this anymore, the Assistant Attorney General for Civil Rights, Devil Patrick, who later became governor of Massachusetts, said, when people said, well, isn't this violate freedom of speech for the Justice Department to continue doing this? He said, well, you can't keep people out of your neighborhood with a baseball bat, so of course you also can't write newspaper articles and that sort of thing. So that was very troubling, obviously, if you're concerned with freedom of speech. Finally, this is not simply a federal issue. I give a bunch of examples of state and local anti-discrimination agencies abusing their authority and threatening civil liberties, ranging from a newspaper cartoonist being threatened with civil rights violations for a cartoon that a local anti-discrimination official found offensive, to people being fined in various states for their choice of roommates, which would seem to violate the right to intimate association that the Supreme Court has recognized. So next thing I do is, well, why might administrative agencies in general be less concerned with civil liberties than we'd like? And first, well, the general academic literature suggests, what do agencies like? They like to expand their own authority. If they constrain themselves by worrying about the First Amendment, they're constraining their authority. Why would they do that? They get less budget, they get less power, and they get less respect from their constituents who are supporting them in the outside world, various interest groups that like them. Second, there's this idea of purposivism, which seems to I'm not an administrative law scholar or such, but I was actually surprised to find, when I was reading the literature, that apparently it's normative in the administrative law world to say that administrative agencies should interpret laws with regard to their purpose, and the purpose means, oh, you have an environmental law. Well, the purpose is to help the environment. That's not how legislation actually works. When we pass the environmental law, we have a compromise. Some people want to go further, some people want to go less far. We protect certain aspects of the environment at a certain price. To then reduce this to the purpose of the law is solely to protect the environment at any cost is incorrect. But if that's what the agency's views are, one thing they're not going to be concerned with, among others, is whether there are civil liberties considerations on the other side. Because the purpose of the law is not to protect civil liberties. Third, agencies attract employees typically who are committed to the agency's mission. If you're going to work for the EEOC, your mission, the reason you joined the EEOC, you want to help fight employment discrimination. You're not there to protect civil liberties. Fourth, agencies often don't see protecting constitutional or enforcing constitutional limitations as their job. And that is often encouraged by judicial precedent and other legal rules about what agencies are allowed to do in terms of worrying about the Constitution. To take the most extreme example, the California Constitution actually explicitly prohibits agencies from ever considering the constitutionality of what they're doing. It's pretty shocking, because that seems like an unconstitutional provision in their state constitution, but it's there, and agencies abide by it. Fifth, agencies, particularly those with a ideologically driven mission, do engage in this sort of administrative constitutionalism that can be at odds with even long-standing black-letter Supreme Court precedent. So those rationales would apply to almost any agencies. There's something special about anti-discrimination agencies. I'm not saying unique, but certain things we could say about administrative agencies that enforce anti-discrimination laws that don't necessarily apply broadly. Well, one thing, those of you who are in the law school world or read the law review literature will note, is that's become very common, perhaps even normative among constitutional law scholars, to argue that the First Amendment is overridden in many cases by the 14th Amendment, that equal protection of the law, or perhaps the citizenship clause of the 14th Amendment, means that the Constitution protects anti-discrimination norms as much or maybe more, since the 14th Amendment came later and therefore amended the First Amendment, then it's more important than the First Amendment. I don't give much stock to this as a matter of constitutional history, constitutional text, or basic constitutional logic, but it's there. I've spoken to many law school audiences over the years, and this is what their professors teach them. Don't worry about the First Amendment when it comes to anti-discrimination laws, because the 14th Amendment overrides it. Relatedly, if you go to the Title IX guidance, one scholar wrote an article about Title IX and said, and this is a liberal scholar who's basically sympathetic. She said what OCR was really doing was not interpreting Title IX, but actually filling in the gaps because they thought Title IX was inadequate. And you wonder to yourself, where do people get the idea that an administrative agency has the power to rewrite a statute? Well, if you think of it as a constitutional concern of equal protection of some sort, rather than a mere statutory provision of power, it certainly makes a certain amount of sense from that perspective. Finally, I discussed some reforms that might alleviate some of these problems. And most of the reforms I suggest are reforms that would apply very broadly and affect administrative agencies very broadly, like don't allow agencies to avoid judicial review by issuing guidance letters instead of going through notice and comment. That's a very important reform, and in fact, I just noticed the Justice Department just today announced that will no longer allow employees of the Justice Department to rely on guidance letters for enforcement purposes because they say those have no legal weight. It's only the actual regulations that have weight. But no one's going to do that solely because they're worried about the First Amendment. There are a lot of reasons to do that. So are there any reforms that we could undertake that might actually make administrative agencies more cognizant of First Amendment concerns that would not require broad administrative reform, however desirable that may be? And the one that I came up with I kind of like is there's another literature developing in the Legal Academy about what they call offices of goodness. So if you are the Justice Department and you're going after terrorists and you're worried, well, we're going to violate the Fourth Amendment, you establish an office of goodness at Justice, at the FBI, at NSA, who worries about whether the Fourth Amendment is being violated, whether the First Amendment is being violated. And they serve as a counterbalance to the more zealous people who say, well, my job is to get the bad guys. I'm not worried about the First Amendment. So you have people institutionally who are worried about the First Amendment. I think we could use the same thing in institutions in the government, such as OCR, such as the Justice Department's Office of Civil Rights, and so forth. Thank you.
David Bernstein's paper has alerted us to a very serious problem. And if any of you had any doubts about the seriousness of the problem, I think Stuart Taylor's lunchtime talk would probably show you that civil rights regulation can be a very serious threat both to freedom of speech and to due process and to freedom of association. Those of us on the panel, I think, have some problems with David's causal argument, but I don't want that to be interpreted to say that we don't appreciate the seriousness of the problem. As a matter of fact, I'd say the problem's even worse than David suggests. And I would put it this way, that not just agencies, but often courts, advocacy groups, legal scholars have been instituting a new understanding of anti-discrimination statutes. And that understanding goes as follows, that the only sure way to eliminate discrimination is to eliminate the stereotyping that underlies discrimination. That is stereotyping on the basis of race, gender, disability, even age. In order to undo that stereotyping, you not only have to change institutional policies, you not only have to outlaw certain types of behavior, you have to change the way people think, because that's where stereotypes really exist. Therefore, you have to re-educate people about how to think about race and gender and sex and disability, which is one reason why we see this development most clearly on the campus, where educators are trying to change the way people think about all of these things. That not only threatens free speech and due process, but I think threatens a very understanding of the line between private and public that underlies liberal democracy. So I think this is a very serious problem. Now, what are the causes? David suggests two causes. One is organizational and one is ideational. So my biggest problem is with the organizational argument, so let me pursue that first. His argument is that the problem with civil rights organizations is that they are filled with true believers who ignore countervailing concerns in the reckless pursuit of equality. Like all bureaucrats, they seek to expand their power and their budget, and courts have been too timid in restraining them. Now, as Stuart Taylor has suggested, the most egregious examples of restrictions on free speech came not from the bowels of the bureaucracy, but from the Obama administration and to some extent from the Clinton administration, although that took place 18 hours before George W. Bush took office, and what a classic example of midnight regulations. I would add to that the courts played a very important role in building these legal doctrines. that OCR often just incorporated court doctrines, although not what the Supreme Court said, which it ignored, but lower court doctrines. Now, my bigger problem is with the argument that I realize is very common in the public choice literature about the tendency of agencies to expand their budgets, their power, and their authority. Now, as a student of James Q. Wilson, I can't accept this. Because as Wilson argued, some agencies certainly do that, but many agencies don't. Many agencies would prefer to maintain their autonomy and therefore not to expand. As a matter of fact, the personnel for Office of Civil Rights has declined precipitously, or is about half now what it was in 1980. And in the 1980s, OCR was a relatively timid proceduralist organization. So those generalizations don't apply. Now, I mention this because I think that it relates to our understanding of the administrative state. And what I find interesting, important about American administrative state is not particularly administrative. It tends to be judicial as well as administrative, politically driven as well as administrative. So I don't think we should focus too much on this model of bureaucratic expansion. Now, the second argument that David makes is basically, I don't want to caricature too much, but basically say that this is really a battle between the bad agencies that take too broad an understanding of civil rights and good courts that are really concerned about protection of freedom of speech. Now, I'm old enough to remember when conservatives were not thrilled by some of the Supreme Court's decision on freedom of speech and were not anxious to expand judicial review as in some of the ways that David advocates. But the broader point I want to make here is that we can't overlook a really fundamental problem in civil rights regulation, which we can't solve, we have to cope with, which is there is unavoidably a conflict between the preservation of equality or the furthering of equality and the preservation of liberty. That's not something that was the result of recent mistakes. Go back to Tocqueville, he said that's a fundamental feature of democracy, the battle between liberty and equality. We did have to sacrifice some forms of liberty in order to undo the legacy of Jim Crow and slavery. And I think we've got to look at that and say, yes, that is true. So the problem is not so much whether we're going to try to instill the correct version of the battle between liberty and equality through the courts, but rather whether we can rethink or we can think clearly about the way in which this could be made in a better balance between the two, one that doesn't go to the extreme that I described at the beginning about this vague effort to eliminate all types of stereotyping. Therefore, the proposal that David put forth about more transparency and rulemaking that Stuart talked about, I think will be a start in that direction to force us to look at the choices more clearly, not to have them made incrementally with courts doing a little bit and agencies doing a little bit, so we're not really sure how we ended up here. So I think that that type of transparency can lead to a better debate in the battle between liberty and equality that is a perennial feature of liberal democracy.
Move this over a bit. First, I want to just thank Adam and the Center for inviting me. I'm really delighted to be here, and it's fun to be able to meet David, because I should also say at the outset that I teach evidence and expert evidence, of which he is also a big scholar, and I have been very much I found his work very useful, and I've relied on it very much. I should say, though, that in this area, I find myself in a lot of disagreement with him. And I did question why I was invited, because I said, I actually am not an expert about anti-discrimination. I don't know that much about many of the examples that he gave. And I think that it surely must be because I wrote a book called, or I wrote an article called Citizens United and the Threat to the Regulatory State. That involves a rather different sort of anti-discrimination argument, one that I will come to later, but it seems kind of inappropriate to use this occasion at which I'm supposed to talk about David's paper to talk about my own research. So I'll just say a few things. I think that all of us on the panel have some of these reservations about some of the claims here. And one of the first ones is that in the introduction, and I think some of the references, it seems like we have the claim or the suggestion that this is an indictment of administrative agencies generally. And I think if you look, and indeed I thought that at first, and when you look more carefully at the paper, it does seem to be specifically about the anti-discrimination or those agencies tasked with anti-discrimination sort of briefs. And that's a very different thing than saying administrative agencies generally do not recognize or protect the First Amendment. There's also sort of a state, federal, and municipal, and I think there are some important distinctions in terms of the constitutional significance of the regulatory environment and the response in all of those areas that also make generalizations somewhat dangerous in this context. But I think my biggest concern with this paper, I mean, I think it's filled with a lot of what are essentially empirical assertions about what people do or what they don't do in these agencies that I think perhaps could be fleshed out a bit more, and we could be offered with some more specific examples in addition to the ones that he does give. And that some of this is the kind of thing that people who already agree with you will agree with those characterizations, will agree with those sorts of labels, but those who don't agree with you are not likely to agree with you unless it's somewhat more modestly framed. So I would urge that maybe that's a project that might make the paper more persuasive in some ways. The big problem, though, for me, I think, is the way in which it assumes that the First Amendment is a thing. It's a thing that has been pretty stable and that everybody knows what it is, and that it has been stable for this period of many, many decades. And of course, we know that it hasn't been. In fact, a lot of us gathered here in this room know that it has not been. One of the things that's interesting about the First Amendment is the degree to which it has not been stable over some of this period of time, in the last 20 years in particular. What I wrote about, and I wrote about this as well in a book called Brandishing the First Amendment, was the way in which it seems like there's an anti-discrimination narrative that has arisen that actually is directed towards both the content of speech with respect to commercial content and the identity of speakers, that is, commercial speakers or corporate speakers, that has generated a real shift in the literature or in the Supreme Court precedent that has presented this dilemma for the administrative state more generally. And not just because there may be some conflict which pre-existed this development between anti-discrimination or our commitment to equality in the 14th Amendment and our commitment to freedom of speech, but rather because we used to have something that seemed a little bit more like a division between that which we considered commerce and sort of unambiguously commerce and under the Commerce Clause and regulable under the Commerce Clause, and that which we considered speech. And that there was, to be sure, a lot of a wavy line there. There were a lot of products that were speech, and principally, newspapers, books, entertainment, and so forth. But by and large, with respect to the labels that people put on their products, on their widgets, on their pharmaceutical products, on their cosmetics, and so forth, nobody thought that that was expressive speech entitled to First Amendment protection. That changed in 1976, as most of you probably are aware, with Virginia Pharmacy. And at that time, that change was oriented towards protecting the interest of listeners. And just like rights to equal rights, or 14th Amendment rights may be sometimes in conflict with First Amendment rights, the First Amendment, to the extent that it has a speaker component and a listener component, also presents a dilemma of which right you're going to uphold or defend. In many cases, we didn't think about that very much because it was most of the precedent, to the extent that it existed, was oriented towards speakers. And that was what everyone conventionally understood was covered. 1976 in Virginia Pharmacy changed that by talking about the interests of the listeners in hearing drug prices. The development that has come in the last few years seems to have been a development that has been the interposition of this idea that commercial speakers are no less entitled to this protection than listeners, that commercial content is no less protected than other types of content. And that has raised the very real specter, and this could be a good thing if you like it, or a bad thing if you think it's a bad idea. And maybe with respect to those agencies devoted to issues of discrimination, maybe it's a good thing. But with laying a gauntlet, throwing down a gauntlet with the regulatory state generally. That is to say, almost anything can be reconfigured as a First Amendment issue. And things like saying, when the SEC proscribes what kinds of things you can say for a public offering, when the FDA says you can't say certain things about your drugs, when the FTC says that certain kinds of comments about your product are not acceptable for you to say, or requires you to post a warning or to post a label. All of those things are not content neutral. They are, in fact, directed at a particular kind of content. And it raises this very real question of whether or not we have, I can't use this timer because it keeps going off. Whether or not we have a situation in which we have this sort of threat to the regulatory state that we had become accustomed to, at least in the 20th century. Now, as I say, if you think that's a good thing, perhaps this is a good development. But I think Professor Bernstein's paper sort of proceeds as if the First Amendment that he's referring to, and indeed in the HUD examples and in the campus speech examples, is a more conventional sort of First Amendment kind of problem. But the developments of the First Amendment doctrine have not been stable. They have not been uniformly understood in a particular way, and it might be worthy or worthwhile to, especially if this project is one that's going to be a statement about administrative agencies more generally, worth noting. I guess my final point, since I'm getting close to the end here, is just kind of taking issue with the sort of the structure or the taxonomy or the problems that he identifies, and particularly the last three. He says anti-discrimination agencies attract people who are interested in the mission. I would say, as opposed to who? Should we hire people in an agency like the FBI or any other agency who are not interested in the mission? That seems to be problematic. And the idea that they would interpret their briefs as fulfilling that statute or pursuing the aims of that statute, it seems odd for anyone who is interested, let me just finish this thought, interested in sort of the either judicial or agency humility, that they should not have a wide-ranging brief to undertake an office of virtue. That strikes me as a somewhat troubling kind of fix. So with that, I'm finished.
Okay, terrific. Thank you. So let me just say a couple of things about just a couple of very general points, and then talk a little bit about David's paper. So one general point, I just want to say I really appreciate the invitation to speak here as a person who, was a mission-driven career attorney in the Civil Rights Division of the Justice Department early in my career, and then an aggressive political appointee in the Civil Rights Division later in my career. I'm sort of the target of either David or Shep or both. Or Stuart Taylor. So I appreciate your having me here, and particularly at a time when there's such a tendency these days for everybody to talk within their own camps. I just think these kinds of conversations are incredibly useful. And I will say, throughout my career as a legal scholar, the work of David Bernstein, who's a person who I disagree with on many things having to do with civil rights law, has been incredibly important to me in kind of engaging with and helping me kind of understand the issues that we're confronting. We can have a disagreement over whether I've engaged with it well enough to actually understand it. But I think it's been very important, and so I'm really happy to be on this panel responding to him. And I have a slightly, I feel like I'm in a weird position in some ways, because almost exactly a year ago, I was speaking at the Duke Law Journal's Administrative Law Symposium, which was dedicated to the idea of civil rights in the administrative state. And I was responding to a paper that's actually cited in David's paper by Bertrand Ross at UC Berkeley, which was very celebratory of the idea of administrative agencies infusing constitutional values in what they did, and administrative agencies as a site for developing constitutional values, exactly the thing that David is critiquing. And what Bertrand said was essentially, this is really good because there are all these mission-driven folks who work for these agencies, so they're going to move things in a very progressive direction, right? That was essentially the argument. My response to him was, hey, wait a minute, guy. Have you paid attention to civil rights politics in America over the time period since, I don't know, Kennedy, Johnson, Nixon, Reagan, Clinton, Bush, whatever? Because, in fact, this is the area where you have the most high-level politicization of what happens in the administrative state, of anywhere in the administrative state. The mission-driven bureaucrats, to the extent they exist, and we can talk about that, the mission-driven bureaucrats, to the extent they exist, are very strongly constrained, I argued, by their political superiors. And so if you're giving these administrative agencies the power to develop constitutional doctrine, what you're doing is essentially empowering their political superiors. Now, that might be a good thing or a bad thing, but speaking at a time when probably most of the people in that room, maybe unlike most of the people in this room, when most of the people in that room were not very happy about who the new political leadership was, I thought it was at least a cautionary tale. I have sort of the same, but I have the same response to David, but it cuts in exactly the opposite direction, right? So David thinks that administrative agencies that enforce civil rights laws are a unique threat to civil liberties and the First Amendment, particularly because they're full of mission-driven bureaucrats. I would suggest that actually what's going on in the cases David talks about is not mission-driven bureaucrats, but high-level political decisions, and that the basic disagreement is not a disagreement about what is not a disagreement agreement about who should be deciding, but about something very substantive, right? It's something very substantive about what is the proper scope of First Amendment rights, what is the proper scope of due process rights, what is the proper scope of the equality principle that comes out of the 13th and 14th Amendments. And these are the substantive arguments that people are having. Nearly all of the examples that David gives, I would argue, are one, arguable examples on the law. So David provides a set of examples that he says these are clear indications, these are clear instances in which administrative agencies have simply ignored the First Amendment. As Tamara suggested in her previous comments, I don't think that's actually right. I think that what's going on instead is there are complicated legal issues here. There are legal issues on which people can disagree, reasonable people can disagree. If we're talking about Title IX, obviously most of that's not about the First Amendment. There's a First Amendment piece, but mostly it's about due process. These are difficult due process issues, right? Due process issues involving the burden of proof in not just a civil but an internal administrative proceeding within a school where the sanction is potential expulsion, potential stigma. There are arguments that that should be clear and convincing. There are arguments that that should be preponderance of the evidence. What most people are really arguing about there is whether OCR, whether the Office of Civil Rights at the Department of Education properly interpreted Title IX. The due process issues are really complicated, and there's no clear resolution in the case law one way or another. Same thing with the issue of confrontation. There are very few due process cases that require criminal trial style confrontation in internal administrative proceedings like that, as well as the other aspects. So there's really, what's going on there is an arguable set of positions, and an arguable set of positions that, interestingly, the career staff at OCR did not implement, right? When was it implemented? It was implemented under the Obama administration when Vice President Biden and the politically appointed head of OCR, Catherine Lehman, decided this was a major priority. A major priority would be getting rid of violence on campus. Again, you can agree or disagree with the calls they made. That was not a product of the folks in the mission-driven bureaucracy. Okay, so other examples David gives, HUD, a few examples from the most recent is 1996. I think it's again very telling that who's the quote from? The very telling quote that David supplies from Deval Patrick, the then head of the Civil Rights Division, political appointee, later to be elected governor of Massachusetts. This was an administration priority. It was not a priority of the career staff. Yeah, there were some cases in HUD that started during the George H.W. Bush administration, but it's really only a smattering of cases. The state and local examples that David gives, I mean, look, there are lots of examples of overreach and underreach by state and local officials in the civil rights and every other area. I think the crucial set of cases that I think gets a lot of oomph here is the Masterpiece Cake Shop style cases where state and local officials are using their authority over civil rights, particularly in the LGBT discrimination area, to get at people who have a conscientious or religious-based or expressive-based objection to the civil rights laws applying to them. And what I will say about that is, and again, this goes back to what Tamara said, that is an area where the First Amendment issues are extremely arguable, right? There are strong, reasonable arguments on both sides. I have a set of views about them. I think they're probably diametrically opposed to the set of views that David would have about them. If we were predicting what the Supreme Court would have done on those cases at various points over the last 40 years, we would have come out with predictions that went in opposite directions, depending on the composition of the court. Had Merrick Garland instead of Neil Gorsuch been on the court, I think we would have an opposite prediction than perhaps the one we might have now. So this is not an example of administrative agencies subverting the Constitution. It's taking one of a set of arguable, reasonable views of the Constitution. Okay, so is this about institutional incentives? I don't think so. I think it's about values as infused through politics, values that get reflected in the decisions of high-level political decision makers. And let me offer a counterexample that suggests, how this works. I mean, so from my own time as a civil rights official. So when I was in the Obama Justice Department, one of the issues that we got a lot of pressure to take on was an issue of speech on campus. But it was not speech about sex. It was not speech about race. It was speech that was supporting the BDS movement, proposing boycott, divestment, and sanctions of the State of Israel. And what many people, mostly people on the political right, but not entirely, what many people said was, this is harassing speech. If you say that Israel should be boycotted or divested from or sanctioned, then what you're doing is you're harassing Jewish students. That's a violation of Title VI of the Civil Rights Act, right? That was the argument. And the Obama administration said, look, we think discrimination against Jews is a violation of Title VI of the Civil Rights Act. We don't think criticism of Israel or even calls to boycott Israel are discrimination against Jews. Now, if what civil rights officials cared about was, pursuing the most expansive reading of civil rights statute, über alles, right? Unfortunate to use German in this context, sorry. But, if that's what we cared about, then what we would have said is, well, of course this applies, of course the statute applies. But that's not what happened, because there was a difference of opinion about how the statute applied and about whether there was a First Amendment right at issue here. And that's, I think, fundamentally the set of arguments, that's fundamentally what the arguments in David's piece are about, right? They're not, I would suggest, about administrative agencies always under-protecting the First Amendment and over-protecting civil rights. In fact, what they're about is we have a lot of disagreements in this country at the grassroots level and at the elite professional level about what the First Amendment means, about what civil rights law means, about the equality norms in the law and how they weigh against the free speech and liberty norms in the law. Exactly as Shep said, this is a long-standing problem. It is an ineradicable problem because there is an inherent tension between these various commitments that we all have to liberty and to equality, and how we manage those tensions is something that changes over time. It's the subject of political disagreement, and what we are seeing in the cases that David talks about is the political disagreement manifesting itself. I don't think we can draw any general rule about how administrative agencies behave from that. But I think it's a really interesting paper, and I'm really happy to be part of this discussion. So thank you very much, and I will turn it over to the rest of the panelists for discussion.
Alrighty. So I'm going to give David a chance to respond, and then let the other panelists chime in a second. I wanted to throw a couple things out that might be worth thinking about in the discussion. One is the question as to whether the phenomenon that is being discussed here is merely a particular manifestation of agency tunnel vision that Justice Breyer wrote about in his famous book on regulatory reform, which is a variation of the what happens in agencies that are highly mission-driven, but simply the idea that agencies tend to focus on maximizing a particular part of their goal and tend to systematically undervalue other things. And if that is part of what's going on here, then I think one question that comes out is, what is it that makes questions related to discrimination and civil rights rise to the fore? So, things we didn't hear about were, the TSA officials being overzealous about people taking photos of what occurs at an airport, which we know occurs and there have been issues with, or debates over whether or not local police departments respect what some people believe is a right to record or a right to monitor the police, right? Which arguably could be an example of agencies that we tend to think of in very different terms, not being sufficiently protective or concerned about types of expressive activity. One possibility that I'll throw out, and I don't know if this is right, and I'd be curious what people on the panel think of it, is under current doctrine at least, most forms of discrimination require speech as evidence. That is to say, we doctrinally, certainly at a constitutional level, disparate impact, unless it is particularly severe, Yikwo versus Hopkins type levels, is not enough. And so typically in the context of discrimination, what one looks for is speech that provides evidence of the impermissible motive. And if that is true, if that claim is true, does that necessarily put agencies that have some sort of anti-discrimination mandate or some sort of civil rights mandate, does that necessarily thrust them into debates about speech that other sorts of agencies might not necessarily be put in? And if so, is that something that's in the background? But anyway, David, I don't know if you wanted to respond to that or respond to comments from other panelists. Take 2 minutes.
Okay, first, I think the tunnel vision point is an important one. It's not that agencies are always, quote unquote, better on civil liberties than courts. It's just that, a judge knows that their obligations both to interpret the statute, but also to be concerned about other legal things like the Constitution, whereas that's just not the agency's mission. And therefore, one would expect overall agencies to be less concerned with non-mission driven issues like background civil liberties than courts. Second thing I want to mention is on the issue of top-down, it's kind of an interesting question. Because, for example, as Stuart mentioned at lunch, President Obama himself claimed to be in favor of free speech. I actually blogged about this at the time. I gave him 2 cheers for saying I believe in free speech in colleges, whereas some of his appointees were going the other way. So this wasn't actually the administration position. This was the position of OCR that President Obama was not actually adopting and never defended publicly, as far as I know. So, and while this is partly driven by political appointees, it's also true that all these settlements that are being negotiated with these universities on due process, all the investigations where they're going back 3 years. These are all career lawyers who are can't be supervised each individually by Catherine Lehman doing this, and they have to sort of think they themselves could be worried about the civil liberties implications. But as far as I could tell, there was no internal dissent on this kind of thing. So I think it's a combination of top down and the bureaucrats themselves, so to speak. And finally, I think Tamara made a very good point about the First Amendment not being fixed, the 40th Amendment not being fixed in stone. It goes along with Sam's point about these being values in dispute. And I think this is one important reason to have the transparency, to have actual notice and comment periods, to have the president defend what his people are doing if they're going to be doing it. Because what we have, instead of actually having a debate, I mean, the First Amendment, I'm not one of these people who think, oh, it's a fixed, originalist point of view. I understand how constitutional development actually works. There are controversies. We decide these things. But when we let the agencies do it sort of at a level where only people like Stuart and myself and a few other people are really paying attention, the New York Times is misreporting all of it and so forth and so on, the average person has no idea what's going on. We're not really having a public debate. Should we bend on First Amendment issues or due process issues because of the importance of campus sexual assault or campus racism or whatever? We're having sort of an internal coup. That's a little bit of exaggeration, but sort of an internal coup by administrative agencies who are doing things under the radar where only a few really alert political people are paying attention, and they're avoiding judicial review by issuing guidance and whatnot. So we're not even having a debate in the courts. So I think so I agree, let's have the debate about the values, but let's do it in a much more transparent way.
Since I participated in the criticism of David's paper, I want to point out something I think that is very important that got underplayed a bit, and that is his discussion of purposivism in interpretation. And I think this kind of the best fullest statement of that is William Eskridge's book on dynamic statutory interpretation, which assumes that you not only can have discretion as an administrator or a judge within the language of the statute, but you can amend the statute. Let's face it, just like Weber, and the Weber decision was a key argument that Eskridge makes, you can just, you ought to have living statutes that change with the times. And Title IX, the number of times in which agencies and courts have simply ignored what Title IX says are quite dramatic. There's no effort of claiming that you should have Administrative Procedures Act procedures. There's no effort to have these regulations, as is stated in the statute, be signed by the president. The primary enforcement mechanism is to cut off federal funding. How often has that happened? 0. 45 years, 0. Why? Because we have invented implied private rights of actions that were not in the statute. And I'll just take one other example, which is the transgender rights DCL issued by the Obama administration. That basically says when the statute says you can segregate facilities by sex, it doesn't actually mean sex. It's got to mean gender identity, which is different from sex. So, I mean, you have to completely make up new interpretation of, not just interpretation, you have to rewrite the statute for that. And to the extent, I mean, there is where I think that I agree with David, the extent to which this actually carries over from one administration to another. So that these, I think, very dubious readings of the statute become embedded not just in regulations, but in case law because of deference to by courts. And that has led to an understanding of the statute that is really quite far afield from what the statute actually says.
So just adding to your.
If you want to, yeah, sure.
Well, I think one of the things that's striking to me, and this is sort of, underscoring that these are hotly debated issues, is the way in which what gets identified as a conservative or a liberal or progressive opinion has changed so dramatically in the course of, the 50 years or so since Virginia Pharmacy. And so, Virginia Pharmacy, the dissenter in that case was Chief Justice Rehnquist, who would not have been anybody's, idea of a liberal, I don't think, anyway. And in the sort of intervening years, there's been quite a shift so that I think a lot of people understand, that the position, and without getting into the distinctions between conservative and libertarian and so forth, that understand that by and large, the conservative position is pro-speech. But what that means is, of course, really hard to tell when the doctrine's changing so much. So there was a case in 2003, I think, Marty, you can correct me or someone, Nike v. Kasky, which caused a rift between the ACLU National and the ACLU of Northern California because they couldn't agree on what the appropriate stance ought to be in that case and which position was more speech protective. So the mere fact that somebody invokes the First Amendment doesn't mean that it's actually First Amendment protective in some sort of absolute way, or that everyone agrees that that is the position that's going to be most protective. I feel a little bit like one of the things that's happened here is that, like in response to the Masterpiece case or Masterpiece Cake case, is I feel a little bit like invoking Milton Friedman, and saying, what do you have against capitalism? I mean, one of the things that a distinction between business and other things and, a commitment to economic efficiency and, certain principles about running businesses and Milton Friedman's very famous observation that the only social responsibility of business is to, its duty to its shareholders, was that it kind of smoothed over some of these political disputes, some of these, moral disputes, so that, nobody asked whether you were a Republican or a Democrat in order to sell you a chicken sandwich. It's just like, do you want to sell chicken sandwiches? Is it a good chicken sandwich was the question. And now it seems like it is much more de rigueur on both sides of the political aisle to combine, the attempt to combine business and what might have previously been thought to be moral or political issues, including, the issues about anti-discrimination.
So let me just say two quick things before we do more. I mean, so one is on this issue of transparency and the Dear Colleague letters. And I will say, I've always thought that issue was the issue of Dear Colleague letters or guidance as an abuse of power was a little bit overblown, and we're now seeing why, which is it's internally within the government, I was always against doing guidances and Dear Colleague letters because I thought they were really weak, because they're only as good as a court's going to agree with it or the next administration's going to keep doing it, right? And so I often, when I see these arguments about guidances and Dear Colleague letters, find myself kind of agreeing with half of the critique and then totally disagreeing with where the critique goes, because I think it's absolutely right. I mean, the guidance has no force of law. What it does is it tells people, so Shep's shaking his head, what it does is it tells people what this incumbent administration or until the next administration decides what to do with it is going to do in enforcing this statute. But the instant it's challenged in court, I mean, we saw this in the GG case, right, with the transgender guidance. I mean, so if you look at the brief that I filed in the GG case with some other scholars, we didn't make the argument that sex means gender, which doesn't mean sex, right? We made a different argument based on the statute. I think we were right, but like we'll never know. I think a lot of people thought that the plaintiff in that case was going to lose because the instant that a very aggressively progressive guidance document hit a conservative court, the conservative court was going to read the statute and say this is what we think, right? So I don't think that's as big a deal as people say. And you get a new administration which comes in and in OCR they've just ripped up a bunch of these guidances. The Associate Attorney General, as David said this morning or last night, issued a memo saying essentially we don't want any DOJ lawyers relying on guidance documents in affirmative civil enforcement. And that's something that's always available there, which may not be as available with notice and comment rulemaking. So I actually think that it's a very weak tool, doesn't have the force of law, and probably shouldn't, almost certainly shouldn't, but, all it does is it has an interim effect so long as the regulated parties know that the regulators who issued the guidance are still there, and that's a very ephemeral thing these days. I also want to say one thing about actually the very smart point I thought Jonathan made about, well, why do we talk about this in the context of civil rights agencies as opposed to anyone else? And I think the point about the evidence is really smart, that in order to show intentional discrimination, most discrimination statutes and of course the constitutional prohibitions on discrimination have been limited to, or at least their strongest aspects have been limited to intentional discrimination. They're obviously disparate impact statutes, but they tend to have more limited remedies than statutes prohibiting intentional discrimination. So because intentional discrimination is the thing you have to prove, how do you prove intent? One way to prove intent would be a pattern. Well, look at this. The pattern that results is very disparate, but Jonathan's right. Most courts say, yeah, a pattern can be indicative of intent. If you have Yik Wo, where basically everyone who is targeted by this ordinance prohibiting laundries in wooden buildings is Chinese, that's telling you something about the intent. But if you have a less stark pattern, it's hard to do. So what do? You have people's statements. I think this is where, and I think that the cases involving investigations of people challenging the zoning decisions for group homes and the like were a mistake in the 90s. And interestingly, I think importantly, not only did George W. Bush not continue those, but also the Obama administration didn't continue those. But I think what got there was when I've worked on fair housing cases when you have to prove that a zoning decision was intentionally discriminatory, and the only evidence you tend to have is the statements of people at the meetings where these decisions are being made. It focuses you on people's thoughts and people's expression. And I actually think one of my predictions in general is we're about to see another shift in the ideological valence of the intent doctrine. So there's a terrific piece by Katie Iyer at Rutgers on how we now think of the discriminatory intent doctrine of Washington v. Davis. It was a very conservative move. It kind of suppressed a lot of the more aggressive tendencies in the doctrine to have disparate impact. But she makes a persuasive case but what's interesting about that is Justice Brennan joins with the idea that we have discriminatory intent. Justice Marshall joins. The liberal justices all are supportive of that. Why is that? And she makes a very persuasive case that actually throughout the 1960s, there was a big question over whether intent was relevant at all. And it was the liberals pushing the idea that intent should be relevant. And it was the conservative justices who were saying, no, intent isn't relevant. And so we now think at the time, thinking about intent was understood as a progressive thing. Now it's understood as very conservative, but I think between the ferment we're having over the Muslim ban and other cases in which the president's statements are being used, right, which is very valid if intent is the thing you really care about, and stuff like this, and I hadn't really thought about it until Jonathan mentioned it, but I think it's really smart. I think we're in a place where we might be rethinking, who's the side who's supporting the intent doctrine or not.
All right, we're going to Really quick?
Yeah, I just want to say, the reason why I so strongly disagreed with Sam's statement about guidance doctrine, because, and I think here's the difference between me as a political scientist and lawyers. It might not be enforceable in law, but that's not the way in which most of these guidance documents are enforced. Why is it that these guidance documents under Title IX could be enforced despite the fact that they are diametrically opposed to what the Supreme Court said? Because they were enforced by the threat of investigations, damage to reputation, and extremely expensive response to investigations, and also to please internal constituencies. So whether they are legally enforceable or not does not touch the fact of how politically enforceable they are.
So we're going to go to questions. Two really quick things. One, there's a infamous, perhaps, hearing where a Department of Education official asked by a member of Congress whether their guidances were binding. Did not have Sam there this official did not have Sam there to advise him, said yes. And I had a student that had externed at the Department of Education who, when she was in administrative law and we got the guidances, this isn't what they told us. So, I mean, there is, it's not always clear that agencies are aware of that. The other thing I'll just point out, there may be a distinction in the way guidances operate in particular types of contexts. So in the university context, universities with large engineering departments, large medical schools, and therefore large flows of federal research dollars, the threat of even postponing payment on those grants for even a short period of time is seen by grant recipients as a very big deal, whereas in certain other contexts, an agency threatening to act in accordance with the guidance might not pose the same sort of threat. And so how binding guidance is seen may be a function of the sort of regulatory context in which that guidance is operating. Questions, please, again, as always, please identify yourself, wait for the microphone to come around, and we'll start with Marty. Microphone right here.
A quick comment for Sam, and then a slightly longer comment to David. Sam, what you called a counterexample actually proves the exact opposite of what you suggested. Left-wing groups universally support BDS. They're very pro-Palestinian. So when the dust settles, a left-wing administration shut up speech it disagreed with and protected speech it agreed with. Hardly a study in Wexlerian neutral principles. David, as I think you're giving in too quickly on the 14th Amendment superseding the First. The 14th Amendment does not apply to private action. A private individual is not regulated by it. And moreover, advocacy of discrimination is not the same thing as discrimination. You have a First Amendment right to advocate repeal of the 14th Amendment. So for two dispositive reasons, the 14th Amendment has no effect at all on the First.
I'm not really giving up. I agree with you on that. My point is to the extent that the administrative constitutionalists will make the argument that, well, one way constitutional change happens is by working things through is by the executive branch challenging the judicial interpretation of things. I say, okay, if that's your position, let the executive branch, led by the president, make that case publicly, and don't do it through guidance letters that you know will never be challenged, and actually avoid that confrontation.
And my point is there's no case to be made.
Well, I would agree, but
So I don't know very much about administrative law, and I do appreciate your presentation, David, and the comments. But my question is focused on deciding when and if there is indeed a distinction between guidance versus rules that are issued pursuant to notice and comment regulations. And so I don't know very much about deferred action for childhood arrivals, but as I understand it, it was a result of the issuance of an executive memo or a memo by the executive branch. But I also understand there's a court decision in California by Judge Alsup who suggests that that memorandum, whatever it is, cannot be reversed without compliance with notice and comment. So was DACA issued pursuant to notice and comment? My understanding is no, but if so, it strikes me that it's possible that guidance can be transmuted into a rule that has the force of law. I don't know if anyone has a comment on that.
So, a little bit outside my area of I'm not really an administrative law guy per se, but it struck, everyone said, well, don't worry about DACA being done in this way because it could just be reversed by the next president. And then now I think it's troubling that all of a sudden the judge says, no, actually, I could prevent you from doing it. But I'll let maybe Jonathan even answer this because he's the administrative law guy. Before that, let me just say one thing that disturbed me about the guidance is with regard to both DACA before that, the Title IX guidance, is whatever case you want to be made, we're just giving guidance because people need to know what this administration thinks. What's the excuse for not the Title IX guidance came out in 2011. The Obama administration had 5 years, more than 5 years actually, to start the notice and comment period to actually make these into formal regulations. This isn't like a guidance where you're telling a corporate client in a way that only applies to them, here's what we probably think about your tax shelter. This is something that applies to 3,000 or whatever it is colleges in the United States. Broadly, why would you issue a guidance and not start the notice and comment period unless your whole point was to avoid the notice and comment period because you deeply suspect that what you're doing is illegal?
I mean, there's unfortunately not a lot of, I don't want to use the word guidance, a clarification of precisely these lines from the Supreme Court. There is robust case law dealing with some of these questions in the DC Circuit, and at least some agencies have been, I think, quite plausibly accused of issuing guidances or other documents that they want to have the effect of a rule without going through the notice and comment rulemaking, and also are trying to deflect judicial review by doing something that they could argue is not final. And if an agency does something that is in substance a rule, but in the form of a guidance, it is a somewhat unsettled question. I mean, I think there are arguments you can make what the right result should be, but a somewhat unsettled question about then how does one undo that other than by a court order throwing it out? Can the next administration just come in and say, well, the right process was never used, therefore we can just wipe it away? Or is the proper to say, well, because in substance this actually was a rule, it should be treated like that? In undoing it, in part because you don't want an administration coming in and claiming that things were improperly promulgated and then simply trying to wipe them out, which is the exact opposite of the game that some people think agencies are engaged in. And so we may get clarification about this. I'm not overly optimistic because I don't think the Supreme Court, when it gets these cases, actually understands the landscape of these sorts of administrative law questions. But while I think that particular order was wrong in the DACA case, there are some questionable issues about what the proper way to deal with a potentially improperly promulgated guidance or improperly promulgated rule that looked like a guidance, what the right way to undo that is if we in fact think that's what DACA or DAPA were.
Yeah, could I actually add a political science point to this, which there's an asymmetry here, because when you create a benefit, a right, a bureaucracy, that's very difficult to undo. I mean, political science doesn't have too many insights, that's one of them. There's an asymmetry of how people deal with potential gains and potential losses. And once you have a right or a benefit or a bureaucracy, there's an entitlement. I mean, there's a type of reliance there that courts should pay some attention to. And once you create Title IX bureaucracies within universities, no matter what the Trump administration does, they're not going to go away.
Mike? You're first. This Mike first, and then you.
Can I ask a question about the First Amendment or free speech? Shep mentioned that this doesn't look very administrative to you. I think what you meant is it's not bureaucratic legalism, right? And it seems to me that's a political choice we have made in construing the entire administrative state across the board. We don't want it to look like Germany. And that means you'll have a lot of, regulatory dark matter guidance documents, dear colleague, frequently asked questions. You have a lot of deputized private enforcement de facto, right? Because you don't want to build up this big machinery. And you have agencies who will at some point write regs that are a little overbought. I mean, the EPA doesn't really want to, regulate every mud puddle. That's stupid. They just write it that way because they want to keep you guessing, right? And over the general run, I mean, you can, go the full Philip Hamburger on this, but basically that's the regime we've decided to build. Except now when it comes to the sacred First Amendment, people get nervous, right? At the constitutional level, we have all sorts of doctrines that say, wait a minute, we don't tolerate gray areas. That's why there's an overbreadth doctrine and that entire machinery, right? And maybe when it comes to for First Amendment values or interests or whatever, we don't tolerate our style of administrative law, so-called, anymore either. And maybe that's the real conflict. It's not so much between equality and liberty. It's sort of between the style of bureaucratic government that we generally like or have ourselves accommodated to or whatever on the one hand, and our First Amendment obsessions on the other. Isn't that what's going on, or a better lens through which to view this? It's not directed at anyone in particular.
Who wants to respond?
Yeah, 'cause I mean, I think actually that's also really smart, and our First Amendment doctrine has for a long time. I mean, this is not a new problem. Has for a long time had a real difficulty accommodating issues of enforcement discretion, right? When we have a statute or a regulatory regime, either one, that has to be enforced by someone who isn't going to enforce it all the time, but that might trench on First Amendment rights. And so there are all these complicated federal courts doctrines that deal with that. And I think we're seeing that some of that here, where there is this question of whether it's vagueness or chilling effect or whatever doctrinal box you want to put it in. And I think it gets back to the guidance question in this way, because even if we said, okay, guys, no more guidance, we would not solve any of the problems that Shep is talking about, right? So the problems of people being afraid what to do, the problems of regulated entities worrying about bearing the costs of investigations, the problems of reputational harm. Because if you say no guidance, well, one thing that might happen is notice and comment rulemaking. Another thing that might happen is just a bunch of complaints. Right, and the administrative agency says, I'm filing a complaint against, the University of Michigan for violating Title IX, and here's why I think so. And none of us on here thinks that that's administratively illegitimate, but it might have the same effect. Or the head of the OCR starts to give a bunch of speeches with, some suggestions in the speeches, and people start to do Kremlinology around the speeches. So, and that, if you're a regulated entity, whatever kind of regulated entity you are, you're going to do that, right? So I don't think this is actually. I think Michael, you're exactly right. This is a function of the regulatory state, much more than the function of any particular tool that's being used in the regulatory state.
And this is why I say in my book, and I think, this is not directly the sort of question that we're asking here, but the new interpretation of the First Amendment. It's not like saying, oh, it's now coming into contact with our commitment to the First Amendment. It's like a new understanding of the First Amendment, one that has, the First Amendment is, Congress shall make no law. It's a very vague and open-ended sort of injunction. It's a negative injunction about what but Congress shall not do. And for decades, for, probably 150 years at least, there was a sort of a working definition of the stuff it covered and the stuff that it didn't cover. So nobody thought it covered perjury. Nobody thought it covered contracts. Obviously contracts are words. Nobody thought it covered a whole bunch of stuff. Well, now it seems like there is this push to say if it involves words or if it involves some sort of expressive content, expressive being interpreted pretty broadly, I think. I mean, the argument in Sorrell versus IMS Health was, it was just about sale of data. And, the argument that Vermont argued was that this is like selling beef jerky, and that, that argument didn't win. But, I mean, we're talking now about pulling... we're talking about pulling administrative occupational licenses for violation so that the tour guides, the United States for the Edwards case, so that the tour guides who should have to pass a test that they understand the monuments in D.C. It doesn't seem to me to be an unreasonable request that if you're going to charge money to people to show them the sites, that you ought to know what the sites are. Unconstitutional first encroachment on their First Amendment rights. That's the sort of level, I mean, the SEC requires all sorts of things that are now challenged as compelled speech. And there's manners, tombstone advertising. And, we've barely begun to scratch the surface on the level of the things that are challenged as First Amendment. So, it's not a stable thing. And I think you may be right that this is a conflict with the administrative state, but I think that goes back to an earlier decision around the New Deal to say that all of this commercial activity is outside of that. It's under the Commerce Clause, and it's subject to a lower level of regulation.
We have hit our time. Please first join me in thanking our panelists.